Good evening. You're watching Left, Right and Centre. I'm Nidhi Razdan. Tonight, as Arun Jaitley takes on the judiciary in a scathing critique of the Supreme Court verdict on judges' appointments, is a confrontation now unavoidable, or with the Congress indicating a change of stand, will the BJP be able to muster enough political support? Also tonight, as Delhi grapples with the rapes of little children, Chief Minister Arvind Kejriwal says his government wants to bring down the juvenile age from 18 to 15 for heinous crimes. But is that the solution, and has the Kejriwal versus centre war worsened the situation? But first, our big focus tonight, Finance Minister Arun Jaitley's strong criticism of the Supreme Court verdict on the appointment of judges. In the order that came out on Friday, the top court struck down a new law that would give the political establishment a say in the appointment of judges. Going to the extent of invoking the emergency era days, the court decided to stick with the collegium. In other words, judges will continue to appoint judges. In his post, Mr. Jaitley wrote that the judgment upheld the primacy of one basic structure, that is the independence of the judiciary, but diminished parliamentary democracy and elected government, the Council of Ministers, the elected Prime Minister and the elected leader of the opposition. He went on to say that Indian democracy cannot be a tyranny of the unelected, and if the elected are undermined, then democracy itself would be in danger. When emergency was proclaimed, he said, it was people like me, the politicians, who fought out and went to prison. It was the Supreme Court that caved in. The Supreme Court opinion is final. It is not infallible, says Mr. Jaitley, adding that politician bashing is the key to the judgment. Well, the Congress, which had actually supported this new law on judges' appointments, has now backtracked and is attacking the government instead, saying that the centre just wants to control the judiciary.
तो वित्त मंत्री का कल का बयान दुर्भाग्यपूर्ण है। उन्होंने जो अपनी बुद्धिमत्ता उच्चतम न्यायालय को, सुप्रीम कोर्ट को दी है, उसकी आवश्यकता नहीं थी। इससे ये स्पष्ट होता है कि इस सरकार जो संविधान के तहत संस्थाएं स्वतंत्र रूप से काम करने का अधिकार रखती हैं, उससे ये सहमत नहीं है, उसको ये सहन नहीं कर सकते, और वो अपनी बात देश पर और सब संस्थाओं पर थोपना चाहते हैं।
So as the BJP takes on the judiciary, the question is whether it will get support from other political parties and where we are headed in this battle in the weeks and months ahead. Joining us on the program tonight, we have Pinky Anand, the Additional Solicitor General of India, here in the studio with us. Indira Jai Singh, former Additional Solicitor General and Senior Advocate of the Supreme Court, is with us. Jay Panda, Lok Sabha MP of the BJD, Ashish Khaitan from the Aam Aadmi Party, and Aarti Jairath, Senior Journalist, will also be joined by Abhishek Singhvi of the Congress Party. Let me ask Jay Panda this question first, because Jay, I'm just trying to get a sense of where other political parties stand on this issue. You in the past have written a number of articles strongly criticizing the way the collegium system works. And therefore, do I gather that that is the BJD's position as well, and that if the government was to have an all-party meeting on this tomorrow, that you would support the BJP in its stand on the appointment of judges?
First, let me clarify that this latest decision of the Supreme Court has not yet been discussed inside the party. So I will speak in my personal capacity. And let me point out that in the articles and many tweets and other public stands that I have taken on the collegium system, I have said that when it was introduced, it was the correct thing to do, because in the 70s and 80s, there was in fact executive overreach, and there was very arbitrary appointment of judges. So at that time, to protect the independence of the judiciary, that was probably the correct thing to do. But after this quarter century has passed, the situation is quite different, and today we must recognize that we are the only country where the judges appoint themselves. And many judges themselves, after retirement, have criticized the system for lack of transparency. And finally, in any democracy, there must be checks and balances. If you look at the way judges are appointed in the UK, in Canada, in the US, it is never judges appointing themselves. The most that they have is a small say in the matter, and the NJAC, as it had been drafted, still provided essentially a veto for the judiciary in choosing any candidate. So I thought it was a good, well-balanced proposal which all parties supported, where the executive had a role, the judiciary had a role, and civil society even had a role, and these essential balance and checks and balances are important for democracy. So I'm disappointed that the Supreme Court has ruled against it.
Let me ask Indira Jai Singh then to react firstly to what Mr. Jaitley has actually said in his critique. And Mr. Jai Singh, One of the things he says is that democracy, Indian democracy cannot be a tyranny of the unelected, that the Supreme Court's opinion is final but not infallible. Pretty strong words there from Mr. Jaitley. How do you respond?
Okay. First, let me say I'm completely amused by the fact that Mr. Jaitley talks about the tyranny of the unelected, considering that he himself is unelected. I think he should have kept that in mind before making a comment of this kind. But on a more serious note, what I think Mr. Jaitley is saying is we want to replace the tyranny of the unelected, as he sees it, with the tyranny of numbers. The only argument that I've heard against the judgment coming from the ruling party is that we have the numbers, we have the mandate of the people, and therefore any law that we pass must be respected by the judiciary. Now, I think I would request Mr. Jaitley to talk like a lawyer and not like a politician. I think that remark is a remark made in his capacity as a politician, not a lawyer, because I'm very sure that even he knows that judicial review is part of the basic features of the Constitution. And any law, whether made by an absolute majority or whether made by a coalition government, is subject to challenge in the Supreme Court on the ground that it violates the fundamental rights of the people or the basic structure. It is the Supreme Court that has the last word. Unless Mr. Jaitley is suggesting that that should change, I do not understand his comment. Moreover, if he was so enamored by an elected judiciary, I see no reason why he didn't put in an election into the constitutional amendment that was made by his political party. So, for me, the comment doesn't carry much legal substance.
So, Pinky Anand, I'll take what Indira Jay Singh said, that the BJP is talking about the tyranny of numbers, that's the message that she is getting from the BJP's attack on the Supreme Court on this.
Let me first of all say, Nidhi, that I would be speaking on behalf of the government, so that is the position I would be taking very clearly. But what about tyranny of numbers? You're talking about the will of the people. That if that is tyranny of numbers, according to Indira Jay Singh, then I wonder where we are headed. If people's expression of what they want, by way of, for example, this act, which brings into place an independent authority to look into the issues of appointment of judges, is a tyranny of numbers, I think we are going completely off the subject. Here you're talking about a position ultimately, Nidhi, that the people have mandated that an independent commission be set up, and the idea was essentially because there were problems with the collegium system. It wasn't functioning. This was an alternative mechanism which was evolved with the incorporation of a number of outside people, including two eminent persons also, into this entire group, so that there'd be a functioning which is transparent, which is non-arbitrary, which is not whimsical, and in a process which is apparent. Even as per canons of law, you can't be a judge in your own cause. I mean, there is this entire philosophy which lies behind the whole discipline, and as far as the Constitution goes, it only said that the President will not have the final word. There is no other provision in the Constitution about anything else. So, really speaking today, one is wondering where we are going. You're talking about an independent system being challenged on the ground that it's a violation of basic structure because it violates the independence of judiciary. Nobody is fighting against independence of judiciary. Everybody supports that action, including this judicial commission. The idea was to have it so that everybody would know. Today, the process of appointments is not even known to the contemporary judges, aside from the Chief Justice and the Collegium. So what are we talking about? We are talking about, and you know, what do people want? People want today to know. People want to be a part of the process. People want to have a say through their elected representatives, which hitherto had not been allowed. That is where we are.
Then therefore, what becomes critical then is whether or not you get support of other political parties.
I'm not going into the politics of the matter.
I know. I'm saying for the BJP that's important, and therefore I want to ask Abhishek Singhvi. Abhishek Singhvi, you're coming on this program tonight actually in two capacities, because Abhishek Singhvi as a lawyer has taken a legal and constitutional position on this issue, which is actually very different from what his party has been saying, and so he is a Congress party spokesperson as well. So I'd like you to differentiate between those two, Dr. Singhvi, and explain to us firstly, legally, constitutionally, did you think and do you think that the NJAC is a good idea and should be supported?
Well, as far as legally and constitutionally the test you are asking is concerned, I have made my views very clear on day one, and in an article published today I have stated 4 or 5 of those reasons. I do believe that having tried for about 40 odd years a model of consultation and central government judiciary mix, thereafter another 20 years with the collegium, I think a fair chance ought to have been given to see whether the NJAC could work out or not. After all, no system is perfect, and if we have been able to debase and devalue 2 earlier systems, it's a time we decided to experiment with a new one. And the second reason I've given in the article is that in many ways the very virtue which we were searching for, openness, less incestuous inbreeding, less cloistered, quiet decision making, more broad basing, not allowing judges to be the only repository of wisdom, that very vice which was sought to be removed by the NJC was seen as a vice merely because you put in non-judges. Now there is a contradiction there. This is apart from the textual arguments. The articles of the Constitution in fact say the President shall, and what the judgments earlier and now says the President cannot. And nor is there any such language in the Constituent Assembly debates. So on constitutional law and law, generally I would fault the judgment as I have done in writing. But let me tell you, just get back from this and tell you what the larger issue is for political parties today. Today, and now I am speaking totally away from the constitutional law, I believe that there is a very grave feeling in this country for the last several months. There is a feeling in civil society, in different segments of this country, in different political parties across the spectrum, including several allies of the BJP, that institutions are under assault. There is a methodological campaign going on in trying to pack or subvert institutions. Precedents and practices are being changed. Persons with a certain approach are being surreptitiously or otherwise brought in. And I think that feeling exists not only in civil society, may well have been the underlying major or at least the underlying minor premise even for the judges deciding this. Because I think that has heightened the fear, and that is something the government must address. The judgment, though legally and constitutionally flawed, may well be justifiable on that count alone as something which is arising from a fear of the BJP's basic philosophy, or not only BJP but those who control the BJP and the surrounding so-called Parivar elements.
Okay, I need to take that. I need to take that to Pinky Anand. That's a very interesting point you make. So, Abhishek Singhvi.
For a lawyer, I must say it's a very inconsistent argument. Is an argument going to be this, that because there is fear, which according to him there is, there should be no institution because there is a possibility of misuse. Constitutionally and legally.
That may have weighed on the court's
mind. No, but is that a factor to be weighed by the court in any case? I mean, that's an absurd kind of principle or a hypothesis that Dr. Singhvi is thinking about. Courts are not supposed to be going into the political aspects of anything. It is the constitutional aspect that we as either the parliament or we as the judiciary are supposed to uphold. That is the only parameter that is supposed to be adopted. So the possibility of misuse or what the politics of a particular state is doing or what the position may be, which of course I think is wholly flawed. And secondly,
also invokes advantage comments on the emergency.
The question is not of advantages. This is not the way the constitution is run. You don't look into, let us say, sensibilities of people. You don't look into moralities. You look only into the legality and the constitutionality.
So then has the court exceeded its brief?
Well, one is obviously finding fault in the judgment to say this, that this was not the way things should have been. You should have allowed an independent commission to come into existence to look into the entire issues and a transparent one.
Yeah, Ashish Khaitan, the point is, I think we would, I'm sure even the AAP would agree that the collegium system is a deeply flawed system and India needs something different. And as Jay Panda pointed out in the beginning, it's the only country in the world where judges appoint judges. So therefore, what really is the AAP's, why is AAP happy with this court judgment? Let me ask you, is it just the politics of it? Or I ask you on merit, what's the alternative?
Well, having heard long interventions by Dr. Singhvi and Ms. Pinky Anand, I must say that the politics and the constitutional understanding of both the Congress and the BJP is completely garbled. and more in the case of the Congress party, because I don't know what is their stand. Do they stand in favor of the collegium system, or do they stand in support of the NGAC? Having said that, I would like to start by citing the instance of Mr. Gopal Subramaniam's name being referred by the then Chief Justice to the government, this government, to the Modi government, for appointment as a Supreme Court judge. We saw a vicious witch hunt by this government, by its agencies, including CBI and IB, the same agencies which had utmost faith in Mr. Subramaniam's ability to defend these agencies in important cases of public import. They went after him just because they didn't want him to become a Supreme Court judge. And why? Because he happened to be an amicus curiae in Sohrabuddin killing, and as amicus curiae he ensured that Mr. Amit Shah's role was investigated and Mr. Shah was charge sheeted. So that's the record of this government. Now the same government which doesn't want to believe the judiciary, or we say that judiciary cannot be trusted to appoint itself, wants to repose its faith in two eminent persons. Now who are these two eminent persons? For this government, Gajendra Chauhan is an eminent person to head FTI. For this government, Mr. Rao is an eminent person to head Indian Council of Historical Research, who cannot differentiate between history and mythology. So who will be these two eminent persons according to the definition of Mr. Prime Minister Narendra Modi and Amit Shah? We have seen in the past that every government, every political dispensation picks eminent persons of its liking who do their bidding. To replace a collegium system by a system like NGAC, where government picked nominees will select judiciary, is equivalent to throwing out the baby with the bath water. I agree with you that collegium system has its flaws, that collegium system has also erred in the past, but that doesn't mean that you replace a collegium system by a system in which the tyranny of the elected calls the shot, and they pack the judiciary, the high courts and the Supreme Court of this country with the judges who would be willing to do their bidding.
I'm going to take that to the other panelists, Ashish.
Required.
I'm going to take that to the other panelists, but first I want to get Aarti's first comments on this. Dr. Singh, just give me a second. I just want to get Aarti's comments on this, on how this could play out politically.
Only clarification. Nidhi, only clarification.
Okay, go ahead with the
only
clarification.
As I told you, and perhaps you tried to repeat, but Mr. Khaitan didn't get it, my view on the legality and constitutionality is at variance with the Congress. I come in my capacity as a lawyer. I told you that, and you said so. I thought
but
you
Dr.
said
Singhvi,
so.
Isn't the Congress also guilty as a party of double standards on this issue?
It's only the second
you supported as the party, as a government, you supported the NGAC. Today, Anand Sharma and the Congress party is saying the complete opposite. Why?
1 minute. No, 1 minute. I made it clear to you, Nidhi, and I made it clear in my first statement before writing the article, that I do not support the judgment. The Congress does support the judgment. Let's be very clear in case somebody has misunderstood that. So I am not speaking on the judgment. What I have written in the article are my personal legal constitutional views.
That's fine. Now I'm asking you on the
view.
Congress's U-turn.
Secondly, what I am, no, because I told you I am not discussing that part. I am only saying that there is a view in political parties and civil society which arises from the fact that this government is using is subverting institutions and appointing people, and that is a valid concern of Congress and many other parties. That's all.
Is that why the Congress has changed its position?
But didn't you think of this earlier?
Is that why
that certainly would be a reason. That certainly would
is
be a
that
reason.
convincing enough, Aarti, or is
Yes.
it just look? Either parties support the NJAC and the way judges are appointed as a principle, or we bring politics into everything, in which case we will never move
Nidhi,
ahead.
just
The
one
Congress
intervention.
will
Just
also
let
make-
Aarti
allow
come.
me.
Gentlemen,
No.
just let Aarti make her first point. Yeah.
No, I completely agree with you, Nidhi.
Yeah,
I
I
find
just
the
want to make
Congress.
one
Ashish, just a second. Just give me a
I find
second.
the Congress very guilty of double standards. But you know, Nidhi, at the same time, I also am quite amused by this argument of the mandate of the people. You know, the will of the people. I mean, is it the mandate of the people when parliamentarians give themselves a 200% salary hike? Is that what the people have asked for? So, I mean, I think every system has checks and balances. It is very necessary to have checks and balances. And I think just because Parliament passes a law, that is not the final word. We do have a provision for review by the judiciary. And I think that's what the judiciary has done. Now, listen, if the judiciary has some reluctance or some points of concern or is hesitant about the NJAC, well, I don't think the government can drag the judiciary kicking and screaming on this. It has to convince the judiciary, have a consensus, have a discussion, have a consensus, and arrive at something that is workable. Otherwise, it's not going to work.